We have completed up to Article 51, Part 4 and 5 of the Constitution, which related to directive principles of state policy and fundamental duties of citizens. I told you they do not have force of law, they are not legally enforceable, they are only ideals to keep in mind by the government while formulating laws for the country. The next chapter 6 relates to union government. Before going to that, I am compelled to comment on contemporary conflicting issues about which the whole country is tense. In the previous video, I discussed about the dynamics of passing a bill and assenting to it by a state assembly and the governor. The another conflicting controversial issue at present is that in Telangana state, in the 2023 general elections, BRS party has lost the elections and the Congress party has come to power. The assembly seats in Telangana assembly are 119. Out of that, about 66 or so seats were won by the Congress party in coalition with Communist Party of India. Whereas TRS party got about 40 seats and was behind by 1.8% of the polled and valid votes. 7 MLAs from BRS party have differed with the party leader Sri kcr. In practice, in reality, they have joined Congress party. They are behaving hand in glove with the Congress party. BRS party has a petition in the High Court for disqualifying the 7 MLAs under the anti-defection law, which are kept under Schedule 10 of the Constitution. This anti-defection law was brought by 52nd Amendment of 1985 during the tenure of late Sri Rajiv Gandhi. I am sorry to say, this anti-defection law is totally defective. Instead of curbing the defections, instead of being anti-defection, it meant that it wanted wholesale defections. If 1 or 2 people defect from one party to the other, they will be disqualified. If at least 1/3 of the party goes and joins the other party, disqualification is not attracted. That means this is an incentive or indication, an incendiary to say that at least 1/3 of the party must go. It is a very dangerous proposition. If 1 or 2 people defect from one party to the other, powers may not shift sides. Supposing 1/3 of the party goes and joins the other party, the government may fall, a new government may come up. One government falls and another government comes up. This is a very dangerous situation. And the party which is likely to lose the power will not keep quiet. Instead, it will dissolve the assembly and go for fresh elections. This is another disaster. All these things are happening due to constitutional ignorance. In the previous video, I was discussing that majority in the legislatures has nothing to do with the ruling of the state. Government and ruling is that of the governor always, who is the executive under Article 153. Legislatures are different. The job of legislatures is to participate in the election of the President of India and vote on bills and bring the problems of the people to the notice of the assembly. Except this, they should not become ministers or chief ministers or somebody else. Legislative majority has nothing to do with the executive. In India, in the executive sphere, President of India is the only elected executive under Article 55. Article 324 also prescribes only 2 elections for the Election Commission. One is general elections, the other is election of the President and the Vice President. Election of Chief Minister or election of Prime Minister with majority in the legislatures is not contained under Indian Constitution. That is contained in Pakistan Constitution under Article 91 and 130. Unfortunately, that is being implemented in India. We know if an MLA or MP is disqualified, there will be election to his seat within 6 months. So who are losing in this case? If any defect committed, it is by the legislator. But it is the people who suffer without there being a representative for them in the legislatures for 6 months. Even if elections are conducted, their representative may not come, some other may come. And what is the cost of conducting by-elections? Who will bear it? It is cost on the exchequer. Supposing 1/3 of a party have gone, so government has fallen. Before falling, they dissolve the assembly under Article 356 and declare fresh election. Then it means thousands of crores expenditure to the exchequer. So who have committed an offense or who have violated the law, and ultimately on whom the punishment is imposed. So this is a very, very bad law. And moreover, in the anti-defection bill, the decision of disqualification has to be taken by the Speaker of Assembly. This is yet another constitutional atrocity. It is the power of the executive, namely the President and the governors, to decide upon the disqualification of members under Article 103 and 192 in the states. Of course, on the advice of the Election Commission. How you can remove the power of the President and Governor and entrust to a Speaker? After all, Speaker is a party man. He is elected by a political party. If people come into his political party, he will say welcome. If people are going away from his party, he will not take a decision. And moreover, the Speaker himself is subject to anti-defection law. As such, how can you entrust the deciding of disqualification of members to the Speaker? So unfortunately, the President and Governors, being executives who are empowered to assent, withhold or return the bills, they are signing on such bills which even are taking away their own powers. When the powers of the President are reduced or taken away, or that of the Governor, unfortunately such bills also these people are signing. This is perfect misunderstanding of the Constitution and their role as executives under the Constitution. We say the executive power of the Union is vested in the President of India under Article 53, and executive power of the state is vested in the Governor of the state under Article 153. Both of these executives take oath under Article 60 and 159, which reads, "I, to the best of my ability, preserve, protect and defend the Constitution of India and the law. And I devote myself for the welfare and service of the citizens of India." Such an elaborate, high-sounding oath is it? I preserve, protect and defend the Constitution and the law. And I devote myself for the service and well-being of the people of India. What are they doing towards this? And to keep up their oath of office, this is most unfortunate. The President of India is being elected by the Electoral College consisting of all the MLAs and members of both houses of the Parliament without issuing a whip. Is unfortunately confined himself to Rashtrapati Bhavan and satisfied with the royal pompous and artificial honors arranged to him like that of King of England. He is a hereditary man. But President of India is the highest elected authority in India. Not the highest, he is the only elected authority in India under Article 324, read with Article 54 and 55. This is the misfortune, people of India. Now the Honorable Supreme Court has directed the Speaker to take decision within 3 months. accordingly has issued notices to the MLAs, show cause notices, why they should not be disqualified from their memberships. They simply replied, we have not defected. We are still with BRS. What is the proof that I have defected? They must have violated a whip issued by the party high command. This again is another atrocity on the constitution. What is the issuing of whips to MLAs and MPs? One cannot ask his own wife or husband as to whom she or he has voted or will vote. It has to be done through a secret ballot. Even election of the president, issuing of whips are prohibited under Article 55(3). That has to be only a secret ballot. But see, these MLAs and MPs are made to vote openly. According to the dictates of the party, we have eradicated open defecation in villages. But unfortunately, we are not able to eradicate this open voting by MLAs and MPs, which is worse than open defecation. I am sorry to say this. This is not democracy. A person who rules should not have a majority in the legislatures. That is the most ideal democracy. That is what obtains in America. American president does not command majority in the Congress. During his tenure of 4 years, there will be 2 elections to the Congress. He may not get a single seat, but yet, as President of America, it is he who rules the country. He does not need any majority in the legislatures. So is the case of governors of America. They are elected by the people, but in the assemblies, they may not have majority. And majority has nothing to do with ruling of the country. This is a misunderstanding set in right from 1950. So, I do not hesitate to say that India has never been democratic, right from 1950 till date, because there is no effective executive. Without an executive, among whom you will separate powers? How separation of power works? What is the power you have given to the executive? In the constitution, executive power is given to the president and the governors. What do you mean by power? Their power is to follow the advices of their own subordinates. Is it an executive power or duty? If advices of subordinates or servants can never become orders to his masters or to anybody, for example, advice can never be a command or order. If we cannot understand this, even God cannot save this country. Thank you. Thank you for watching my video. I request you to please subscribe, share and comment on my videos. I'll be glad to reply to your worthy comments. Thank you.